Hi, my name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law, so please subscribe to our channel. What are you going to do if you owe thousands of dollars in child support? Well, it's a relevant question, and it comes about a lot. Sometimes the level of support is something you can catch up with. However, many times there are thousands and thousands of dollars of support that have been accumulated. There's no possible way that somebody's going to be able to get ahead of that debt. So what do? Well, you have to find out, you have to reach out to your lawyers and have this discussion with them. Number one, you got to tell them to whom is the money owed. Because if the money's owed to the mom, you have less options than if the money's owed to the state. Now, why on earth would the child support be owed to the state? Very simple. Suppose the mom was on some sort of government aid. Now, they'll pay her that aid, but they'll come back after the dad to get reimbursement, and that's a situation where then the reimbursement's owed to the state. If the money's owed to the state, petitions to discharge state-owed debt can be filed. Your attorney can put motions together to ask the court that you be put either on a payment plan or an outright discharging of the debt based on hardship, etc. You can show the court how much money you have, what your budget is, and all that. And there's been a lot of success in discharging most or all of that state-owed debt. If it's owed to the mom, though, it's a whole nother story. You see, the court doesn't really have the authority to tell someone to whom money is owed, oh, you don't get the money anymore. The only person who can agree to discharge a debt owed to them is the person themselves. So you might be able to approach the mom and ask her to discharge the debt. She might. In most cases, she won't. But there's another possibility, too. It's a possibility that you're talking about a debt, thousands of dollars that are owed to a person, and she hasn't gotten a thin dime, let's say, in years. She might be agreeable, even though you owe 20 grand, to take 7,500 and wipe it clean. Why would she do that? Because, like I said, she, it's great to have a bill that says, oh, you owe me all this money. But if she hasn't collected any money, what's the value of that? She might exchange that for a lower amount on the principal, which will do two things. Number one, put some money into her pocket. And number two, wipe your debt clean. Keep you out of trouble with the courts. So that's another possibility. Your lawyer should consider reaching out to the mom, even if the debt is owed, and say, look, he doesn't have the money, but he can borrow from a relative, for example, but he can only borrow X amount of dollars. If I can get that for you, would you agree to wipe out the rest? You'd be surprised. At least half the time they're going to say, yeah, I'd rather have something than nothing. So if that can be worked out, that would be to everybody's advantage. If you've got any questions about how to do that, reach out, and of course, we'll be glad to help you.